Global happenings today. We communicate. We analyze global news. Stay tuned.
Welcome back to our channel, Global Happenings Today. The Federal High Court ruling today has been an issue of discussion, especially among political class and also legal luminaries, as most of them have spotted what they may call mistake in the judgment. Why? Because it goes against existing judgment. Don't forget that far back, such judgment had also came up in 2020, in 2004, and it was stood against. But first of all, let's look at what Professor Odinkalu have to say, and also Atiku Abubakar. Atiku has decided to speak up concerning it and is hitting straight on the head of judiciary over that same verdict. First of all, let's look at what Professor Chidi Odinkalu has to say. According to this, the professor, a human rights activist and lawyer, has faulted the Federal High Court judgment barring the Central Bank of Nigeria from releasing financial allocation to the Rivers State government until a lawful appropriation act is passed by a validly constituted House of Assembly. Has been reported that earlier on Wednesday that Justice Joyce Abdul Malik of the Federal High Court in Abuja gave the decision in response to a suit filed by a faction of the Rivers State House of Assembly loyal to the former Rivers State Governor, who is currently the Minister of FCT, Nyesom Wike, and led by Martin Amowole. Justice Abdul Malik held that the decision by Governor Luminary to present the Rivers State 2024 appropriation bill to a four-member assembly that was not properly constituted should not be allowed to stand. The court order essentially put a hold on any further funding to the Rivers State government until necessary legislative steps are taken. This means that the state financial activity will be on hold until the House of Assembly passes a lawful appropriation act. The Court of Appeal in Abuja had upheld Amowole as a legitimate Speaker of the House of Assembly, dismissing Governor Luminary Fubara's appeal. This decision comes despite the pro-Wike lawmaker defecting to the All Progressive Congress from the People Democratic Party (PDP), which would typically result in losing their seat. However, reacting to the ruling, Odinkalu, a law professor and former chairman of the National Human Rights Commission, faulted the decision, describing it as tyranny of the #outlaw. According to his write-up in his X handle, he voiced his concern, noting that the judgment overruled the decision of the Supreme Court on a similar case about 20 years ago when the incumbent president Bola Tinubu was the governor of Lagos State. According to Odinkalu, he says 20 years ago, while an official Bat was governor of Lagos State, Supreme Court declined an application to withhold the Federation account allocation of Lagos State LGA. Today, a judge of Federal High Court overruled the Supreme Court. This is not #rule of law. It is tyranny of the outlaw. Also, in a related development, the former Nigerian Vice President Atiku Abubakar on Wednesday warned Nigerian court against setting Rivers State on fire with their judgment and order. Atiku's warning came few hours after the Federal High Court sitting in Abuja on Wednesday ordered the Central Bank of Nigeria to stop releasing financial allocation to the Rivers State government until a lawful appropriation act is passed by validly constituted House of Assembly. Reacting to it, reacting to the court order, Atiku Abubakar, the former presidential candidate of the People Democratic Party, in a statement issued by his media advisor Paul Ibe, said it was appalling that some element loyal to President Bola Tinubu's administration were pulling the strings from behind. According to the statement, Atiku asked why Justice Abdul Malik issued the order when it was public knowledge that Rivers State had already challenged the Court of Appeal judgment on the legality of the Rivers State 2024 budget. The former vice president said last week the Court of Appeal declared that the Rivers State budget was illegal because it was passed by an inconvenient Assembly. The court ordered Governor Luminary Fubara to present the budget afresh. The Rivers State government had already filed a notice of appeal so that the Supreme Court can hear the matter. However, some elements in Bola Ahmed Tinubu's administration have procured a judgment intended to undermine the Supreme Court. Even before the judgment was delivered, legal luminary Femi Falana had alerted the Chief Justice of the Federal High Court, Justice John Suhu, of possible compromise after house gift has been presented to judges in Abuja. Sadly, Falana's warning was ignored. Meanwhile, Atiku applauded the Chief Justice of Nigeria, Justice Kudirat Kekere-Ekun, for summoning judges sitting on the Rivers State cases. He, however, called on the nation's top judge to ensure that those found wanting are disciplined in order to restore the fading glory of God on the judiciary. According to his word, he says Nigeria has descended into the theater of absurd since the Tinubu administration took office. Courts are playing a more ignorable role in fostering political crisis within political parties and even in states, from the emirship tussle in Kano State to the Rivers imbroglio, where court are going to as far as preventing elections from holding, taking Nigeria back to the dark days of June 12, 1993, where polls were annulled. Sadly, under the leadership of those who claim to have fought for Nigeria's democracy, the country is descending into chaos with conflicting orders from Court of Coordinate Jurisdiction flying all over the place, while judges are being induced in the name of empowerment and provision of houses. The result is that Nigerians are gradually losing confidence in an institution which prides itself as the last hope of the common man. Foreign investors will avoid any place where judgment can be bought by the highest bidder. Nigeria should not descend to the Hobbesian state of nature where life is short, nasty, and brutish, where citizens opt for self-help. Rivers State account for almost 25% of Nigeria's oil assets. For a country facing an economic crisis worsened by vandalism and banditry, Tinubu should put his 2027 ambition aside and put Nigeria's interests first. We call on the Nigerian judiciary to restore its image before it gets too late. That was the position of Atiku Abubakar. My colleague is in the house. Complaint is coming in. The first was Professor Odinkalo talking about the fact that the High Court has muscled up so much strength to kick away the precedent set by the Supreme Court. What's your position on all of this?
Let me just say this very quickly. It's ironical that this is happening now. The very person that benefited from the Supreme Court verdict, which is Prof. Bola Ahmed Tinubu, is now the sitting president, now doing same under his government. Same thing is being done to another state by one of his ministers, orchestrated by one of his cabinet members, and is looking the other way. This is the same person. I could still remember one of the reasons why they didn't want the judiciary to begin to interfere with INEC or electoral process, simply because of what happened in June 12, where June 12 was annulled and it caused a lot of chaos. And ever since that time, it was amended such a way that judiciary cannot and should not, distort electoral processes. And now the same judiciary is seen in Kano State trying to stop electoral process from going on in the local government area council. All of this beneficiaries of Bola Ahmed, one of the beneficiaries of all of this, is now in his tenure, about 20 years after, almost forgetting what he fought for, quote and unquote, or what he enjoyed. Now it's now time for legal luminaries cut across the nation to begin to put their searchlight on the judiciary, so that honestly, it's really worrisome that the lower court will set aside the Supreme Court verdict. Usually, one of the things that makes judiciary uniformed and transparent is that whatever it is, they take their stand on the previous ruling, especially if it's coming from the apex court. And now, without regards or recourse to history or to precedents, she just took a stand. Now, the question now is, how would the CJN and the likes begin to deal with this? Are they going to even see them as erring judges? Let's see how it plays out.